Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. This series is designed to give my law students a little something extra, and it's designed for all of us to learn more about our Constitution in our pursuit of more learning, more enlightenment, and more justice, or at least a taste of it. Now, this semester, what I'm doing is I'm doing some short videos on various constitutional law terminology. And for some of them, I'm noting in the text box below the video where you can go back in my series to see the longer video that will explain more the cases and the concepts. For informational purposes only, I will tell you I'm a professor of law at Mississippi College School of Law, and I've been teaching for about 30 years in business schools and law schools. Okay, let's get right to it. Today, what we're going to look at is the difference between procedural due process and substantive due process. Now, some people say substantive, but I like to call it substantive. Procedural due process versus substantive due process. Now, I want to first mention that there are certain rights in the Constitution in the Bill of Rights, Amendments 1 through 10, some say 1 through 8. Those are what are called express rights because they are expressly stated in the text of the Constitution in the amendments. Due process, the rights to due process are found in either the 14th Amendment. The 14th Amendment applies to states, and the 5th Amendment. The 5th Amendment applies directly to the federal government. Okay, so I said there's procedural due process and substantive due process. Now the titles, the names basically give hints in terms of the meaning. Procedural due process means that an individual is entitled to certain procedure when the state decides to deprive them of some life, liberty, or property interests. To make out a claim for a violation of procedural due process, there must first be an appropriate life, liberty, or property interest. And if there is, then due process requires that the individual is entitled to notice and a hearing. Now, what type of notice? Well, there's an older case that says notice reasonably calculated under the circumstances to apprise the person just to let them know what's going on and how they can proceed to be heard. So the nature of the notice requires, it just depends. If the state knows your address, that's where the notice should be given. If the state does not know exactly how to find you, then some other means of notice may be appropriate. And this is covered more in the civil procedure class taught in law school and the criminal procedure class too. Now, you have notice. What type of hearing is an individual entitled to? An individual may be entitled to what is called a pre-deprivation hearing, or a post-deprivation hearing may be suitable. I'll give you an example. Let's say the state is going to deprive you of your life. The state is going to seek the death penalty against you, to be enforced against you. Now, would a hearing after they take your life be sufficient? No, it would not. A pre-deprivation hearing will be required. So the answer is it's going to depend in terms of whether a pre-deprivation hearing is essential or whether a post-deprivation hearing would be sufficient. Now that's procedural due process. In a given case, the individual may be claiming that both their procedural due process rights were violated and their substantive due process rights were violated. Substantive due process. Think about the word, the substance, not the procedure, the substance. Now, substantive due process refers to the unnamed rights for the individual in the Constitution. You're like, say what? Well, we know there are some express rights. For example, freedom of expression is expressly stated in the First Amendment. Freedom of religion is expressly stated in the Constitution. The right to be free from unreasonable search and seizure, expressly stated in the Constitution. But the court says there are other rights that are not expressly stated in the Constitution that the individual still has. These unnamed rights may be unnamed economic rights, or they may be unnamed privacy rights. Now, as we talked about before, the unnamed economic rights, can government intrude on them? Yes, it can. Yes, it can. And constitutionally, the court has essentially held that in general, for unnamed economic rights, all government has to show is the low level, rational basis level. All the government has to have is a legitimate governmental interest, and that the governmental action is rationally related to that interest. That is a low level. Now, if the unnamed right is a privacy right, then generally government must meet a high level. Government must show that it is intruding in your privacy, but that it has a compelling governmental interest, and the governmental action is narrowly tailored to that interest. We talked about all of this last time, I think, when we talked about levels of judicial scrutiny. Now, this is a short clip. So the privacy rights are generally held. Generally, government may not intrude on them unless government satisfies strict scrutiny. I say generally, because as we go on further into the semester, you'll see for some privacy rights, the court has not directly stated that the most exacting level of review will apply. But for now, the point today is for you to be able to distinguish between procedural due process and substantive due process. Substantive due process represents the unnamed rights that are the unnamed rights of the individual that are not directly stated in the Bill of Rights or in the Constitution, but the court has said they are there. In the next clip, I'm going to talk a little bit more about the unnamed privacy rights, substantive due process. This is a short clip. And look, I know you want to know more about this. So look at the notes below and watch for the next video, where I will also tell you where to find the longer clips discussing privacy rights. Maybe you believe in privacy rights. You said they're there. What is the government doing in the bedroom, so to speak, of married people? Or maybe you agree with some of the justices who say, I like my privacy, but the right is not expressly in the Constitution. We will talk about more of this later. Isn't learning fun? Learning is on the path to enlightenment. And enlightenment, I hope, will lead us to justice, or to at least a taste of justice. Subscribe and sign up for notifications, and I'll see you next time. Bye.